Workers' compensation in Michigan is over 100 years old. Back in 1912, Michigan adopted the workers' compensation system as an alternative to the normal lawsuits that had to be filed at that time. There were all kinds of problems for injured workers and their families in proving cases before the workers' compensation law. As a result of the workers' compensation law, a worker doesn't need to show responsibility or negligence on the part of the employer. The worker doesn't have to show that there was no other person that was negligent or responsible, and the worker doesn't have to show that he was not responsible for his injury. In workers' compensation, the issue really is whether or not an injury occurred arising out of and in the course of employment. So this is what we call a no-fault system. The problem with the workers' compensation law in Michigan is that the legislature and the courts have continually amended and changed the law so that now it is not as easy for injured workers and their families to recover compensation as it was originally designed to be. Some of the current hot topics in workers' compensation have to do with the definition of disability. What is a disability? After your injury, are you simply entitled to workers' compensation because you cannot physically do the work? No. Unfortunately, there are new requirements to show, so that not only do you have to show physical impairment in the ability to work, but you have to show vocational impairment in the sense that you have to show that you are losing wage earning capacity. So one of the hot topics currently in Michigan is whether or not a person who is injured and cannot perform his job that he was injured on, whether or not that person has a wage earning capacity in other work for which he is qualified and trained. And that is another requirement that's been recently added within the past 15 years in workers' compensation in Michigan. Another hot topic is, does the worker have the obligation to continually seek other employment at other employers than the original injury? And there are a number of cases now that seem to be holding that these work search requirements are going to be strictly enforced. And if someone is not out there seeking work continually after their work injury, the workers' compensation magistrates, that's the word we use for judges in workers' compensation, they may determine that the person hasn't demonstrated a loss of wage earning capacity. So we have our clients regularly seek work. We have forms for them to use to document their work search. So the work search is another hot topic. And finally, the question of whether or not a person can find work other than the job that he was injured on, and whether or not that work that's out there could be a residual wage earning capacity is another hot topic. So insurance companies now are imposing a hypothetical wage earning capacity on injured workers to try to reduce the weekly workers' compensation they're entitled to. So workers' compensation in Michigan is an evolving set of laws. The benefits include medical. There's unlimited medical. All reasonable and necessary medical care is covered. Weekly wage loss disability benefits, of course, are provided. And then in some cases, vocational rehabilitation is a benefit under the workers' compensation law in Michigan. Again, I want to stress that the law is rapidly changing. It seems like every month there's another decision that changes it slightly. And we are at Ryan & Ryan ready to advise you as to what your rights are and to help you if those rights need to be enforced.